Just when I was out, they dragged me back in again. Yeah, a little bit more politics for you, but, all about the law. And there's some bits coming up that you might actually find quite interesting, hopefully. But yeah, Dan sort of has already done his excellent video on can Liz Truss sue Kier Starmer because she has sent a cease and desist letter saying that Mr. Starmer should stop saying that she crashed the economy. I mean, it's actually quite a while ago that he allegedly said that. Now, just a couple of things. First of all, this is what we could call a cease and desist letter. It's not a letter before action, so it's not a formal thing threatening defamation proceedings. That means it doesn't have to be compliant with the defamation pre-action protocol that sets out quite strict rules about how you identify a claim, although it's clearly couched in defamation claim terms. But at this stage, it's just saying, please stop saying this. Now, I'm not sure that Mr. Starmer has actually said anything. I think it's about the word she's complaining about seemed to be from about 7 months ago. I mean, one thing is, I've seen a blurry copy of the letter, and it makes reference to the statements, but it doesn't identify when or where they were said. Now, it might be because there are some annexes and attachments to the letter, so maybe they go into more detail. Because when you bring a defamation claim under the pre-action protocol and the various practice directions, one thing you have to do is set out specifically the words complained of and when and where they were spoken. Or printed. But like I say, in a cease and desist letter, the rules aren't quite as strict. I've had a look, the firms she's using, they seem sort of very reputable. Because there have been allegations that this is a slap. And people, obviously the SRA are very much coming down on slaps. I mean, that guy from Osborne Clark, he was convicted of effectively... I mean, interesting in that case is that it's not a slap. However, the way you phrase the letter went beyond, what was reasonable by, sort of saying you can't publish this and you'll be in trouble if you do and all that sort of thing. So the SRA do take, frivolous and vexatious attempts at claiming quite seriously. But I think this one, it seems to be well within the parameters. I mean, I noticed the firm, they don't specifically say they do defamation, but clearly it's been written by somebody who, has at least an inkling of what defamation is. But before we move on to, is there a defamation claim, I'd like to introduce you to Section 106 of the Representation of the People's Act 1983, because have a listen to this. Because this section says, a person who, before or during an election, for the purposes of effecting the return of any candidate at the election, makes or publishes any false statements of fact in relation to the candidate's personal character or conduct, shall be guilty of an illegal practice, unless he can show that he had reasonable grounds for believing, and did believe, that the statement be true. There's also a little bit of a get-out, though, because it says, a candidate shall not be liable, nor shall his election be avoided for any illegal practice under this section. Unless it can be shown that the candidate or his election agent has authorised or consented to the committing of the illegal act by the other agent, or has paid for the circulation of the false statement constituting the illegal practice. Or an election court find and report that the election of the candidate was procured or materially assisted in consequence of making or publishing such false statements. So what does that mean? First of all, you've got to make a false statement. But it's also saying it has to be either the opposing candidate themselves or their official election agent. They're not responsible for what other people within their organisation say about an opposing candidate, unless it can be shown that they authorise them to do so. So if people are just off on a frolic of their own, having a dig at opposing candidates, then that doesn't go back on the actual person unless they can be shown that they sat down and said, right, you start sort of having a dig at this person. But brings up a couple of interesting points there. I mean, as to what is a statement of fact, false statement of fact, I mean, that's not defined. And also it's about the character of the person. And, well, there's not a lot of case law in this. The courts have very much differentiated between effectively ad hominem attacks on the person, and then just attacks relating to politics. Um, so there's a case called Woolass. And in that case, his opponent was prosecuted. He was prosecuted for 3 offences. It was alleged that the candidate had attempted to woo extremist Muslims who advocated violence. In particular, to Mr. Woolass, Mr. Woolass alleged that the petitioner's calls for arms sales to Israel was extremist. Sorry, cease sales was extremist. And I'm very grateful to the good people at 45 Grazing Square for this, because they've done a really good summary, which I'm trying not to plagiarise directly, but their commentary is rather excellent on this. They also said the statement that the person had refused to condemn extremists who advocated violence against Mr. Woolass. One article bore the headline, "Lib Dem Pact with the Devil." And also a statement saying, actually, this person doesn't even live in the constituency, despite promising to do so. Saying he's got no connection with this place. Now, at first instance, the person was found liable for all 3. However, and this is have a special election court, and they actually they set the election aside. They voided the result. They also disqualified Mr. Woolass from standing in any elections for 3 years. But when they looked at this, they said, actually, okay, the first 2 are just personal attacks. And, we find them to be false. But they said the third one, it doesn't really matter because that's not a personal attack. That is a legitimate commentary on politics, not living in the constituency. That is something that is actually relevant to the sort of political aspect and not just the personal aspect. So that gives you an idea. I mean, that's one route that arguably would have been open to Liz Truss. Now, chances are, saying somebody crashed the economy, that's something the court said, no, that is just, that's about politics. That's not a personal attack. Saying somebody is crooked or saying somebody, accusing them of criminality that's completely unrelated to their politics, then that would fall foul of this. But the Act seems to recognise that it's a bit of if you're just having a dig at people's political decisions, then that's off limits. That doesn't fall within the Act. It allows people to be as robust as they want in sort of criticising people's policies. So to come back to the defamation angle, I mean, the reason I raise that is I think that if Ms. Truss actually does go ahead with the claim on this, so she does the let before claim and then issues, one thing I can see the court saying is, well, actually, when it comes to politics, this should all be dealt with by the Representation of the People's Act, because that's specifically there to address attacks on candidates, and that sets out the parameters for when somebody is deemed to have gone too far. But when it comes to the defamation, well, Dan's already done a really good sort of overview of all the potential defences. I mean, the first thing is she would have to show that she has suffered serious harm as a consequence of the statements. And, the letter sets out and says, she lost the election, it undermined her chances. However, it's not like it was just Kier Starmer having a digger. I mean, it was an election. Everybody was criticising everybody. So to actually pinpoint and say, it was that statement, what did it, might be very, very hard. The other thing is, when it comes to sort of the defences, you've only got to show that the statement is substantially true. Now, that might be a matter of interpretation, because I know that she's saying, well, no, it wasn't me, it was external factors. But clearly she made decisions. If she'd have just sort of said, I didn't do anything, I just sat there and saw what the world economy did, then arguably, that might assist with the defence. But she passed, she passed financial policy. There were budgets, and people said, well, whatever the world situation, that was the worst thing you could have done in this particular situation. We heard about mortgages going up. So I think it'd be very difficult. And this is going to be one of these things where the courts, where angels fear to tread. Because, there's lots of experts, economists saying, yes, she was responsible or her actions made things worse. I mean, and some people supporting her saying, no, this was the best thing she could have done in the circumstances. And, there was no causative link between her actions and the economy crashing. So if it came to something like establishing truth, arguably you'd have expert evidence, but all the experts would disagree, presumably. There's plenty of experts out there um, that fall on one side or the other of the debate. And I think a court might say, because of that, this is clearly something where you can't really establish whether it's true or not. It just falls outside that, because it's how do you define, what do you have to show it's true or not? Do you have to show causation? Do you have to show it was the only thing that did it? Do you have to show, and you just get into things like what's the definition of crash? I mean, it's a fairly nebulous term. It doesn't have any technical meaning. It's just an ordinary English word. And that makes me think that this really, it would slip into, this is a matter of opinion. And to succeed on a defence of opinion, you just have to say, here's the underlying facts, and people would be able to point to what happened with the economy and say, based on the underlying facts and her actions, it's my opinion that she is responsible for everything that went wrong afterwards, and it's my opinion that her response to the world financial situation caused the economy to crash. And there's probably lots of people who might hold that opinion, and the test for honest opinion just is, it's an opinion that a reasonable person could hold based on those facts. It doesn't have to be an opinion that everybody would hold. It just has to be an opinion that is open to people to hold. The other thing is, when it comes to matters of the public interest, the courts have very much said that when it comes to politics, especially, the public interest defence it is to be interpreted very widely and very generously. And it's a very wide defence anyway. But basically, you'd have to show, was the statement made on a matter of public interest? It's commenting on the economy and who's best to run the country going forward. Did the defendant believe it was in the public interest to publish this, to make the statement? Well, yeah, I think it would be very open to say, I am running to replace this person as leader of the country. So clearly it, is appropriate for me to comment on my political rival and say why I think they're terrible and I would be better. And like I say, they've just sort of held that to be, generally speaking, a sort of a very, very wide defence. And the courts have actually said, they said, when it comes to politics especially, and statements from politicians, every reasonable person would know that there's a partisan element to them. They're not making neutral statements. They are making them for political reasons, and that's how politics work. They're not claiming to be neutral commentators. And because of that understanding that they're partisan, the courts trust people to make their own minds up about things, and sort of go, he would say that, wouldn't he? And just dismiss it. The courts assume that people aren't gullible and just don't believe everything. I mean, the test is, it's somebody who's, a reasonable person who's not too prone to scandal, but not too naive anyway. So I think in this particular case, if you were to go ahead, I think the courts would just say, first of all, I think this is something you could just get struck out. I think the courts would say, this is outside our remit. If she'd thought the statements crossed the line, she could have done something under the Representation of the People's Act. There's also the fact that these statements were made 7 months ago. Now, obviously, limitation is 12 months, so she does have some time to bring this. But again, courts are always, well, if it's that big a deal to you, you would act quicker. So they can actually consider, even if you're in limitation, if somebody applies for a strikeout, they can say, the fact that you're just raising this now, what's the benefit to her? They're not going to overturn the election results. So they'd say, why even bother? The game is not worth the candle, as they say. So I think, they'd probably say, she could have brought something under the Representation of the People Act. But I think they'd probably say, no, when it comes to politics, unless it's an ad hominem attack, that's, where it's an attack on the person themselves and their character rather than their competence, challenging competence is just part of the rough and tumble of politics, and people will make their own minds up about this. So my guess is that this is absolutely going nowhere whatsoever. And like I say, it'd be interesting to see what happens, and if she does take this any further. I mean, she might do, but she'd have to issue a letter before claim, setting out the claim in a lot more detail. I think the response to that would be, because that would trigger a formal response, and I think the response would be, you haven't got a chance, go away. And I think if this claim was to be brought, I think it'd be struck out at a very early stage. I don't think this would not get to trial. I think a judge would just strike this out on the grounds that there are so many potential defences here that the chances of Miss Truss succeeding at trial are just negligible. So why waste everybody's time and money taking it forward? So there you go. Like I say, I'll link to Dan's video because he goes into a lot more detail about the defamation side of it. So just to introduce something new, I thought I'd throw in that bit about the Representation of the People's Act. Because apart from anything else, that's the one that's got practical benefit to a politician because it overturns the election result. Which presumably Liz Truss would have been very happy about if she could have succeeded there. But she didn't, so there we all are. As always, hope you found that vaguely useful, vaguely informative, vaguely accurate.